The Court of Appeals, Division 1 is now in session.
Please be seated. We're on the record now in case CV1458, Allen versus SCF Morris. Counsel, these proceedings are being audio and video recorded. Let me advise you that there will be a link to these proceedings on the court's website within a few days. Please identify yourself and your client when you step up to the podium. Each side has 20 minutes, and appellant, you may reserve some time for rebuttal. We're very familiar with your case. We've read the briefs. We've discussed the case. So keep that in mind. The clock on the podium in front of you will keep track of time for you. And for whatever reason, this seems to be of great amusement to my colleagues, but Mr. Young, you are counsel for the appellant, is that correct?
Indeed, Your Honor.
All right. Your argument.
We're easily amused.
We're easily amused because sometimes I ask how it's pronounced, and because I can't always read the names. But Young, I've got that one.
Thank you, Judge Gold. Sorry, Your Honor, Judge Gold.
That was very funny, wasn't it?
For one, don't
Motion's
do that.
denied. Court's in recess. That's all right. Go ahead.
May it please the court. My name is Taylor Young, and I represent Chantel Allen, the appellant in this matter. Ms. Allen is here in the audience today. The issue in this appeal is whether SCF National Insurance Company can take advantage of the protections afforded under Arizona's claim statute, ARS 12-82101, to public entities. As the court is aware, that statute requires parties with a claim against public entities to file a notice of claim within 180 days of the claim accruing, and failure to do so bars a party from bringing a claim in that matter. We don't think SCF National Insurance Company can take advantage of the protections under ARS 12-82101 for one very simple reason. It isn't a public entity. And there's really no question in this case that SCF National is not a public entity. When any entitlement that SCF National might have had to claim status as public entity vanished when the Arizona legislature abolished the state compensation fund, which was then called SCF Arizona.
Well,
They didn't abolish. They moved the state. Didn't they move the state compensation fund into a different entity?
I don't think
And
that
now
that's...
it's a totally different entity.
They privatized it.
Well, the privatizing language is obviously the language that the appellees like, and it's language that one can see in the legislative history, and looking at if one were to go outside of the record and look at sunsetting provisions about SCF Arizona. But if you actually look at the language of the statute, what the language of the statute says is that the agency is abolished. And I'll go ahead and reference specifically that statute because I think it's an important point.
well, the statute refers to a successor mutual insurer corporation.
Correct.
That suggests that the new entity is a different entity and the other one.
No longer exists. It's an entity. There's been a transfer of all assets and liabilities to this new private successor mutual insurer corporation.
As we considered this case, I didn't really think about this, but can you continue suing an entity that doesn't exist anymore?
Well, Your Honor, that's a good question. However, in this case, SCF National Insurance Company is the defendant, and it existed prior to this transfer of SCF Arizona. And that's frankly one of the riddles in this case. This case is decided on a motion to dismiss, a very skinny record. And when appellate counsel comes in and starts, digging around to try and see what's going on here, it may be that we don't have the fullest record on what SCF National's actual status is. But we know,
Well, the other part of the statute, another part says that the successor corporation is responsible for the obligations of the state compensation fund. So are you going to have to bring in the new body at some point?
well, Your Honor, just to be really clear, we've sued this workers' compensation policy that was that we're suing under in terms of bad faith. That workers' compensation policy was issued by SCF National Insurance Company. SCF National Insurance Company, based on public records, and I've cited to the link of where you can look them up, was formed in 2010. That was before this transfer of SCF Arizona. What appellees argued below and what they've argued in their briefs, they assert that SCF Arizona was privatized, and then this new parent company is their parent company. They're a wholly owned subsidiary. So SCF National Insurance Company never ceased to exist. It wasn't abolished. What was abolished was SCF Arizona. And unfortunately, we just don't have a fully developed record on this, Your Honor. I'm loath to go into some of the details that are available from legislative history to see
But
what SCF was
Arizona
doing.
SCF Arizona was the public entity.
And SCF Arizona, there were a number of sub-entities, all called SCF one thing or another, that were created in 2010 in anticipation of the privatizing. This is, I think we're getting far afield, but it is a good question, Your Honor, about who the defendant is in this case, and that's why I wanted to be really
I
clear.
guess it's not our question.
The defendant in this case is not SCF Arizona. The defendant in this case is SCF National Insurance Company, which they allege, and we say in our brief that we don't have any way to challenge them on this record. They allege that they were a wholly owned subsidiary of SCF Arizona before, and now they are a wholly owned subsidiary of Copper State, which is the new name for the new entity.
That National was a subsidiary of Arizona?
National. Yes, Your Honor. And that's who issued the policy in this case, and that's who we sued. Okay? Now, there's no question that SCF National is private. The only question is whether it was public when its parent company, SCF Arizona, was public.
A subsidiary implies like ownership, doesn't it?
Your Honor, they have not cited any law that says a subsidiary does apply in terms of the character of something as a public entity naturally falls, but we have assumed for purposes of this appeal that SCF National Insurance Company was a public entity when Ms. Allen's claims accrued. Frankly, the argument just was not developed below, so I didn't feel comfortable on appeal that we could challenge that argument, to be perfectly frank with the court about what's going on. So we just don't have any discovery on that. If there was no discovery, this is a motion to dismiss.
I just hope we don't have to get too metaphysical here.
Your Honor, I don't think we have to get metaphysical in this case, because if we go back to the language of the statute, and that's really what this case is ultimately about, SCF National cannot invoke the protections of the claim statute because SCF National is a private entity, and they will concede, they'll get up here and concede that they're a private entity. They'll say they were public back when Ms. Allen's claims accrued, but there's nothing in the statute that says a private entity can invoke the protections of the Notice of Claim statute to bar a claim just because they may have been a public entity back when the claim accrued. And if you look at the specific language of the statute, we can go to the definition of public entity, but I don't want to belabor it. It's cited in our briefs. They're not going to allege that they aren't they're not going to argue that they aren't a public entity. But if you look at how the statute, what the statute sets forth, it says that pardon me, Your Honor, I'm pulling up the specific language. And I somehow have gotten old.
Happens to all of us.
Thank you.
Gold.
Persons who have claims against a public entity or public employees shall file claims with persons or persons authorized to accept service for the public entity. In fact, the term public entity is repeated over and over again. And in our briefs, what we argue is, if you look at the status of this, what happened here in the timeline is that Ms. Allen's claim accrued in October. SCF Arizona, the parent company, and for purposes of argument, we'll assume SCF National as well, converted to be a private entity or lost its public entity status, or its parent was abolished and a new entity that was definitely private existed on January 1 of 2013. That was before the 180-day notice of claim period had run. It was well before it. It was 78 days after Ms. Allen's claim had accrued. At that point, if you're Ms. Allen and you're reading this statute and trying to determine, do I have a claim against a public entity? The answer is no. SCF National Insurance Company, who my claim is against, is definitely not a public entity. Now, what if I have a little bit of question about that? Maybe they might be a public entity because they used to be a public entity. How will I understand whether or not they're a public entity? Well, what am I supposed to do? I'm supposed to file a notice of claim. Who am I supposed to file the notice of claim with? The public entity. Well, there is no public entity, so how am I supposed to file a notice of claim? If I file it with SCF National Insurance Company, they're a private entity. I'm now filing a notice of claim with a private entity. Well, what about the provisions, or what about the public policy behind this? The public policy behind the notice of claim statute, as the court is aware, is to protect the public fisc and prevent public liability. Okay, allow for, as a taxpayer, I want public entities to have the opportunity to review a notice of claim, make good decisions, protect the fisc, budget accordingly. Are any of those purposes served by serving a notice of claim with SCF National Insurance Company, which is definitely a private entity? No. Is there any way that my claim is going to get back to the state of Arizona? No. We know it can't get back to the state of Arizona. The statute abolished SCF Arizona. It transferred all the assets and liabilities. It said, new entity, these are all yours. There's no path back to the public fisc. There's no path back to public liability at all. And so if I'm reading this statute and deciding, do I have a claim against a public entity which has to be filed? The answer is no. Now, we point out in our brief some of the other considerations that one might look at in terms of the timelines associated with this in determining how can I comply with the statute when what was the public entity has failed to maintain that public status throughout the notice of claims period, which is essentially what we concede for purposes of this appeal happened here. And we look at some of the other provisions in the statute, things that we need to do. Within 180 days, you need to file a notice of claim with the public entity. Well, in this case, that would mean 78 days is all you had, because on the 79th day, you're not filing with a public entity, you're filing with a private entity. Now, the other side suggests that our hypotheticals it sort of dismisses our hypotheticals as we were walking through all of these considerations and suggests that they would never have argued if we had filed a notice of claim on day 79, they would never have argued, well, it's too late, you needed to file one on 78 because we're a private entity now. We still get the benefit of the notice of claim statute, but you had to comply while we were private. And then if we look at the Prescott case, this court will recall that substantial compliance isn't enough, and the statute is strictly interpreted. And that case involved a notice of claim that had a 15-day trigger on the settlement offer, because as the court's aware, you have to indicate what you'll settle for. And what the court held was, no, that period of time, the 60-day period of time, is exclusively in control of the public entity. You don't get to shorten it. Well, in this case, would Ms. Allen have been required to file a notice of claim with a public entity in such a time that it maintained its public entity status so that the quote-unquote public entity could do its financing, do its budgeting, assess its liability, and decide whether or not to accept the offer. If that's true, then Ms. Allen's notice of claim would have been due 18 days after her claim accrued. And it can't be the case. And that's the effect of reading public entity to include what's happened here. So the simple and straightforward matter here, Your Honor, is that a private entity cannot invoke the protections of the public entity statute. One other thing I want to mention, and then I'm going to attempt to reserve the rest of my time, I'm happy to answer any questions the court has, of course, is the two cases that figure prominently in the appellee's brief. There's the NORAD case and the Munoz case. And we've distinguished those cases in our brief, but I want to emphasize a couple of things. In the NORAD case, that's a federal court case. Despite the fact that the trial court seemed to think maybe it was bound by it, it wasn't, and neither is this court. But in the NORAD case, well,
it's a trial court opinion from a magistrate judge.
It's a trial court opinion from a magistrate judge in federal court. And in that case, the question was, if you are a public employee and you are no longer a public employee, is a notice of claim still required? And that court held yes, in fact it was. But the reasoning is really important, because the reasoning there was that the public employee's liability leads to a public entity's liability. And if the court looks at the definition of public entity is the state or any agency of the state. So the NORAD decision is about whether or not a public employee must be served, and in that case, yes, because it could lead to public entity liability. Here, serving a entity that is no longer a public entity serves no purposes. It does not result in any public liability. It cannot result in any public liability, so there's no reason to apply the NORAD rationale here, and the trial court simply missed that. The Munoz case, I would ask the court to look at carefully. That's a Colorado federal court decision interpreting the Colorado statute, which has some similar features. But what, again, important in that case is that they held that a doctor, in that case they held a hospital was entitled to an immunity cap, even though it had converted to private, and the doctor was no longer in private practice, because there it was conceded that the doctor was entitled to the liability cap. And so what the court said is, well, since the hospital's liability is entirely derivative of the doctor's liability, because that was the only theory, there was no independent liability for the hospital. It was all respondeat superior. What the court said is, since the hospital's liability is entirely derivative on the doctor's liability, and we hold that the doctor is entitled to this immunity, we're going to also apply it to the hospital. That's a very different situation. Unless the court has questions, I'd like to reserve the rest of my time for rebuttal.
John? Thank you, counsel.
Thank you.
Is it Mr. Gibson or Mr. Hunt?
How about Mr. Warashek?
Mr. Warshak.
Does that one show up?
It does.
It's a little bit harder name.
That's why he tried to avoid it.
That's not necessarily true, counsel.
Thank you, Your Honors. My name is Mark Warashek, and with me is Nick Bender from the firm of Sanders and Parks. We represent SCF National Insurance Company in this matter. As I listened to the argument here, the first thing I noted was how oddly the issue was framed. And the issue was framed as by my opponent as, can SCF take advantage of public entity immunities? Almost as if there was something wrong with that the legislature had enacted. And finally, I think halfway through his argument, he got around to the real issue, which I will frame, is whether the notice of claim requirements and public entity immunities apply as of the time of the alleged culpable conduct or at the time the lawsuit was filed. I think that's our real issue. And maybe let me put it another way. Our public entity immunities, such as those contained in ARS 12820, absolute immunity, qualified immunity, punitive damage prohibition, 1-year statute of limitations against public entities, and the 180-day notice of claim statute, available to and triggered at the time of the alleged culpable conduct or some other time that is going to float. For example, under plaintiff's assertion, it will float depending upon when the entity privatizes or not. That, to me, is the issue. And our thoughts are here that the court should affirm Judge Cooper's dismissal of this, because clearly the more predictable and the more fair way is to apply a public entity deadline, public versus private, at the time of the culpable conduct.
Well, can you just tell me whether the public entity that was SCF National exists?
I don't think the record's developed at this point to that extent. I will tell you that
And on the record, doesn't it depend on the statute?
that I can tell you this, that SCF National was set up with a couple of other entities at a time to allow SCF Arizona, a public entity, years ago, to remain competitive, because they were not allowed to do different pricing mechanisms like the private market was. And so there was a movement to allow them to set up wholly owned subsidiaries that were controlled and run by and fully owned by public entity SCF Arizona, simply for the pricing aspect, so they could offer different levels of insurance to what were considered very good risks, and maybe higher pricing for what companies were not good risks. And that's why they were set
I
up.
can understand the state of Arizona owning buildings, but I'm having a hard time understanding a public entity corporation owning another corporation.
Well, and when you say another corporation, it was a subsidiary, it was a company, and now as I'm sitting here, I might be wrong on that. I can't remember if that was a corporation or not. I can't tell you if that was. I can tell you it was a wholly owned subsidiary set up for the purpose of pricing. And the complete control.
I mean, I could see an agency sort of creating a sub-department, and the sub-department of the agency carries out certain aspects of its public responsibilities. But I'm still having trouble with the ownership part. I understand how one corporation in the private sphere owns another corporation because they own the shares in the subsidiary corporation.
Sure.
But of course, we don't have that arrangement with a government agency or a public entity, right?
Well, we did in this case. We do know for a fact that SCF Arizona controlled, owned, and completely, actually completely owned all the shares of SCF National Insurance Company. We do know that. Let me go ahead if you don't know if you.
Listening.
It's interesting, the difference here in how this is being approached, but the statute itself requires that persons who have claims against a public entity or public employee to file a notice of claim. And the word is have, a present tense, and the trial court got that right. What does that mean? What does the word have? The trigger is at the time the claim arises. And we know that. And we know that because the statute refers to it directly, because it ties when the notice of claim is due to the accrual of the claim. In other words, that the 180-day notice is due from the accrual date. It's not from some other date or some other fashion. The perceived difficulties that plaintiff encounters in what do I do if it's 78 days later and the entity is no longer public and it becomes private. Who do I serve it on? Well, you serve it as the statute requires, on the person authorized to accept service. That isn't a difficult concept. There is a successor. There is some money to accept service. Choosing any other trigger date for determining whether public entity immunities apply, any other trigger date other than the accrual date, would certainly lead to confusion. And how do you apply that? How do you get to a trigger date that isn't set and tied to a accrual of the claim date.
Yeah, but I'm not sure the assertion is that he's arguing about the trigger date. I think the argument is that the obligation went away when the SCF National ceased to be a public entity.
That is what he's arguing, that the obligation went away.
But he may acknowledge that, well, as of that trigger date, the 180 days started to run or whatever it is, but it also ended when SCF National essentially ceased to exist.
So let's play that out for a second. Let me think through that with you as we struggle with that one. Let's keep our facts the same, that SCF privatizes on January 1, 2013. And let's take plaintiff's assertion that he knew there was no public entity to serve. And let's say the event, the culpable conduct, took place the very end of June 30th, 2012, 6 months and a couple days before the notice of claim was due. So clearly, plaintiff would, under his arguments here to you, assert that I'd have to file a notice of claim on December 30th, 2012, right before the privatization, because that's what he's arguing. It's going to float, but we're going to use that deadline because SCF was still public at that time. But now let's take it a step further. The lawsuit has to be required against a lawsuit must be filed against a public entity within 1 year. That 1 year would be triggered at the end of June 2013. But now, under his argument, we no longer have a 1 year statute of limitations against public entity. We're going to float that to the general 2 year statute of limitations because of this argument here that they're not private at the time. There's no public entity to sue at the time.
Well, but under your hypothetical, the 6 months runs out before January 1st. Either files or he doesn't.
Right.
And that cuts it off, which, it's not necessarily a float. This is different because the time to file the notice of claim occurred, that 6 month period occurred in a different hiatus, in a twilight zone area.
Sure. It certainly, my point was simply, are you going to distinguish between the two, whether the public entity loses its public status while the notice of claim is due, while the 1 year statute of limitations is due, or some other time? That was the point I was trying to reference. But you, Judge, you're exactly right. This was in that different period of time. But let me take it one step further. The conduct itself occurred when the entity was public. So if we're going to do this, are we now all of a sudden going to remove the punitive damage prohibition that public entities are entitled to? Are we going to increase the liability of this entity even though the conduct occurred?
Well, couldn't the legislature have taken care of that when they changed the entity?
Well,
By legislation?
I guess that maybe the deeper issue is, if this is now a successor private company, what is the financial risk to the government at this point?
At this time, we would have to say there is no risk, but I can...
So why does it, so I guess that's the answer, isn't it? All those protections for the government entity don't apply to a private entity, and they wouldn't have any implication for the government because the government's not liable anymore. It's the private entity that's liable. And in terms of, unless the government has a continued stake in this, unless the state of Arizona has a continued stake in it, why would those defenses for the public entity apply?
Well, certainly the state of Arizona has no more continued stake in Copper Point any more than they want this workers' compensation carrier that offers the vast majority of comp policies to Arizona employers. They don't have anything more after January 1. But certainly in the whole privatization, the legislative process, the whole goal was to make this company, this entity, this organization succeed to provide affordable workers' comp insurance to Arizona employers. And part of that discussion and part of that process was certainly the fact that as of January 1, they weren't assuming debts that of a conduct that occurred that would implicate punitive damage type exposure.
When I listen to you describe this set of circumstances as unusual and the implications it has, I understand what you're saying, but at the same time, isn't it just this is a very unusual situation? You have a public entity that is abolished, or whatever term you want to use, and a new private entity comes in and takes over. That just doesn't happen very often. This is an unusual set of facts. The state of Arizona doesn't go away and hand over its duties to a private corporation.
Yeah, I have to agree. Do you see this every day? But you certainly see it more as many of the state compensation funds across the United States are now privatizing. There are several before SCF Arizona, 3, and there are more in the works. Public hospitals, like the one in Colorado, went from a public entity to a private status.
Well, you can even see it in the federal government with Medicare Part C and the MAs, where the private entities come in and they are responsible. They get the capitation payments from the government, but they're responsible for paying the claims. So, I mean, it's just kind of a different thing that we're seeing now.
Yeah, it is, and you know, the real risk is can we, should we, under some guise that it's not involving public funds, the 6 months later or the 9 months later or the year later, at whatever floating deadline we pick, all of a sudden drive it, as opposed to when the culpable conduct occurred. No successor company wants to take on greater liabilities than its predecessor. And the whole point of successor liability is that they take on the liabilities of the successor, but no greater than that. And in this case, having any rule other than the public immunities attach at the time would do just that, that the liabilities would be greater than the.
Tell me, if you would, if this is a correct statement. During the 180-day period for filing a notice of claim, SCF National and its parent company, SCF Arizona, ceased to be public entities, and their obligations passed to, quote, successor corporations.
I think I would have to agree with that. There's a couple other points I want to make. We talked about this being, Judge, the not norm. You don't see this every day, a public entity going private. But as my opponent referenced, there have been 2 instances at least, or at least the Colorado instance, and these are federal court cases. But what we do notice is that we don't see any cases adopting an approach having a trigger deadline other than the accrual of the claim when the culpable conduct took place. Both NORAD and the Munoz case that addressed it both used that trigger, and there wasn't any limitation to that. In other words, that it would only apply to the public employee, not the public entity. In either case, the real inquiry and what the court spent its time on was, when did the conduct occur? And if the conduct occurred when the entity was public, then the immunities applied. But there's a whole host of other immunities that we haven't got into, but the absolute immunities, the qualified immunities, and those type of things that you run into danger with a broad sweeping rule like this. And if you try to fashion a rule, like plaintiff says, how do you even do that, considering the 1-year statute of limitations and the 180-day notice of claim? Going back to my example, my hypothetical, if the notice of claim is filed at the end of December because it's due then, but the entity ceases to be public after that time, are you going to require the claim to be filed within 1 year, which is what the statute would provide as to public entities? And then if you do, why is that different than the notice of claim? In other words, there's going to be confusion. There's no bright line rule. And part of what we litigants look for and strive for is clarity. And one of the ways that we can clarify this is, if the conduct took place when the culpable conduct took place when it was a public entity, keep the public entity immunities and requirements and protections there. If the culpable conduct took place when the entity was private, apply the separate set of rules to those non-public entities. That provides clarity, it's predictability, and it's something that litigants can understand.
Well, I can come up with a scenario that's can cloud the issue even more. What if the privatization occurs while the litigation is pending and strips what was a public entity of actual immunity defenses while the case is pending? I don't know what the answer to
Yeah,
that
how
is.
confusing can you make it?
I can make it very confusing.
Yes, and that to me brings us back to why the clarity and the need for clarity and certainness, and the fact that we aren't pushing on greater liabilities, greater exposures to successor corporations than what the corporation owned or the entity owned when it was public. So I'm going to just kind of wrap up this way. Notice the claim requirements, the 1-year statute of limitations against public entities, the public entity immunities, including the punitive damage prohibition, must be, in my opinion, determined by a clear and predictable date. And the only way we can do that is to pick the accrual date of the claim, when the culpable conduct occurred. And from that standpoint, we would urge the court to affirm the dismissal of the complaint by Judge Cooper. And unless you have other questions,
Thank you, counsel.
thank you.
Mr. Young?
Thank you, Your Honor. I want to just highlight a couple of points. I think that the court has caught on to the real issue here, which is that there is no public liability at all from Ms. Allen's claim, and there can't be. And the parade of horribles that successor corporations to state public entities that privatize are going to take on greater liability than they anticipated is something that clearly could have been addressed by the legislature, and I would argue was addressed by the legislature in the session laws when they made this transfer happen. The language, and Judge Thompson's already pointed to it, is that the successor mutual insurance corporation, and this is subsection D in the session laws of chapter, it's chapter 268. It's said in our brief, section 4, subsection D. It says, the successor mutual insurer corporation is responsible for the obligations of the state compensation fund to the same extent as though incurred originally by the mutual insurer corporation, including all obligations assumed by intergovernmental agreements and so forth. They very well, this concern that we're going to have expanded liability, contingent liabilities, this is what one does when you create a succession plan, and that's what they did. And
But
so
we could theoretically read that language as meaning the obligations to the same extent as though incurred originally by
by the successor.
Yeah. You could read in there sort of implicitly that the successor gets the same protections because they're getting the same obligations.
I would say the opposite. I would say the successor, what is the successor? The successor is private. Very clearly that is private. So what is the successor's, as if it had been incurred by the successor? Well, that's as if it had been incurred by a private entity.
It also would seem that the legislature could have protected the successor corporations by explicitly requiring compliance in this kind of case.
And I agree with you, Your Honor. And my time is up, but I do want to point out that the clarity that appellees are asking for is not at all clear when you look at our parade of hypotheticals that we've provided as well. So there, unfortunately, the clear path here is to ask the question, are you a public entity? If you are a public entity, you can take advantage of the public entity notice of claim statute. If you aren't, you can't. And it doesn't get more clear than that. We would ask this court to please reverse the judgment of dismissal below and allow Ms. Allen's claims to go forward.
Thank you, counsel. We'll take this matter under advisement and issue a written decision in due course. Court's in recess.